Yes. So welcome Raquel Peixoto, who is one of the many or few, depending on from which angle you are looking at it, collaborators of the Permanent Bureau at the Hague Conference. And we are very proud to have you here in Lucerne to present to us your views on the both choice of law principles and on our dataverse. Of course, you are a very informed user of both of these instruments, and we are very excited to hear from you. The organization that has inspired the entire project itself. Rachel, you have the floor.
Thank you very much. And it's also a pleasure to be here in Lucerne. It makes it extra special to be in person. Thank you for organizing this conference and on behalf of the Permanent Bureau to giving us the opportunity to celebrate the principles, the 2015 principles on international commercial contracts, and 10 years after their adoption. So I have the very difficult task to speak about the principles in front of Professor Giersberger. So I hope I don't say anything silly. But for us, it's a very important instrument, and which is pretty much still alive in our work, not just as in terms of visibility of the work that was done to come to the principles, but also with the work that we are doing now at the Hague Conference. So we are still discussing party autonomy, limits to party autonomy, and how it works in cross-border transactions, specifically in the context of international commercial contracts, but also in other new contexts as well. So I prepared a few items, but and also thank you, Agatha Norik, for the team here of the Code Dataverse project. Thank you for the warm welcome and the preparatory debates as well that we had already. And I focused my presentation on party autonomy and private international law, the work of the Hague Conference, but also looking back at the main features of the 2015 principles, because I think this is also important in the context of this conference and the tool that you have launched as a very important tool. So I've prepared like a presentation taking stock of the principles and looking at three interconnected elements. First, the preparatory work that shaped the principles and its main features. Then how the development in the normative work of the Hague Conference provided us the opportunity to ask new questions in relation to applicable law and party autonomy. And that's also where the diversity of legal systems comes into play more and more. And then to reflect on the current stage of normative work in private international law in the work of the Hague Conference, considering also the membership of the Hague Conference currently, and why tools such as the Code Dataverse are particularly interesting in that context as well. So I've prepared a bit of short timeline with the institutional context. So as Permanent Bureau, we keep a good documentation of our preparatory work, but I think many of you will be aware of it. But it's interesting to come back to it sometimes to reflect why certain decisions were made on a certain direction, right? And why they're relevant sometimes in the current context again. And the principles were approved in March 2015, following several years of preparatory work that started in 2009. And what is also interesting for us from the Hague Conference is to remember that in the mid-2000s, member states and observers identified the need for a global instrument addressing choice of law as a standalone issue. There was nothing like this before, right? So there was a lot of discussion together with judgments, with jurisdiction, but there was a need to come up with a standalone instrument. And then there was a lot of exploratory work between 2009 and 2012. and the group met several times. I don't need to elaborate on that. But in 2012, the Special Commission chaired by Professor Giesberger came with the final draft principles, and they were broadly endorsed, providing the technical but also the political momentum to finalize those 12 very important articles, which are 12 articles which are short, but they contain a lot of information and a lot of work that went into it. And it was the first and the only soft law instrument from the Hague Conference, and the first one dedicated exclusively to choice of law, to party autonomy in international commercial contracts. I think what is unique about the principles, I put here 5 features. I think everyone knows them quite well, but in the context we are discussing now, it's good to remember why they are so relevant, looking back at those 10 years, because they also relate to the diversity of legal systems and the jurisdictions that are implementing them now and inspired by them. They keep on finding the importance of this broad approach to party autonomy. So the first one is that the principles adopt a broad understanding of party autonomy, and they allow the parties to choose applicable law expressly or implicitly, to make that choice at any time, including later on. So there is subject to the protection of third parties, but there is a certain level of flexibility there on the understanding of party autonomy. The second one is that they recognize severability and flexibility in the choice of law. So, as you know, parties may select different laws for different parts of the contract. And this also reflects the complex structure of international commercial agreements. The third one is that the principles place emphasis on legal certainty and predictability. And this makes it, why is that? Because they contain clear rules on the scope of the chosen law. So on issues such as assignment, interpretation, the remedies, thereby it really makes it clear for the places where the principles are inspiring, either the legislative reforms or the judgments, what is the clear scope of that, the effects of that choice of law agreement. The fourth one is that the principles also delineate limits of party autonomy. And that's also not just, of course, mandatory rules and public policy of the forum, but those articles that deal with that are very rich in explaining, including the use of the law of the forum, but also the use of foreign law in terms of public policy. So they're also very innovative and unique in that sense as well, from what we see in private international law. And another final distinctive element that, of course, you're very aware of that, is the openness to non-state law. And we also think this is very important, including in the context of arbitration. And we've seen that a lot coming as a result of the survey as a very important feature as well, but also because it reflects commercial practice, not just a theoretical approach, but also commercial practice. And that makes it distinct from the domestic many of the domestic regimes, and gives also a new opportunity or possibility for international commercial contracts. So coming back to the work of the Hague Conference, we can say that from 2015 to 2022, we had a lot of work promoting the principles, the awareness of the principles. We know how they influenced developments in legislation, in regional, including in Latin America, but also in Africa, the development of the African principles, then legislation in a number of places. And in 2022, we had the Codify conference, which was also very important because that's when the Permanent Bureau started work on the commercial, digital, and financial division. And there, the work of the principles became, again, a very important source of questions and answers on the current private international law issues that were resurfacing in the work of the Hague Conference. So, for example, the experts at that conference, which was really rich in information, was not just the influence of the principles, but also new issues, right? On the context of digital contract, automatized contracts, platform-based issues on international transactions, not just business transactions, business to business, but more generally. But we had, of course, a lot of questions that came back to think about the principles and the scope and the exclusions. And now, what happened since 2023, 24, 25, and now, that there is a wave of new normative work at the Hague Conference. We have currently 3 new experts groups, and all of them study the principles, which is really interesting. All of them consider, every time we go into the aspects of applicable law or in choice of law and the limits of party autonomy, our first point of call is the principles and where the principles cover, and that is quite a lot is already covered by the principles. But we also have areas, because we are talking about not new topics, the digital, for example, digital platforms, payments in central bank digital currencies, for example, and we are also looking at carbon markets transactions, and all of those are posing very new, interesting questions on the limits to party autonomy. So, of course, for example, in the expert group for central bank digital currencies, you have a huge amount of public policy issues being discussed, and in sovereignty, for digital tokens and platforms. Then we are also thinking about business-to-business transactions, but as users within a platform, and a lot of automatized and smart contracts, and to what extent something is different or something is still the same for the context of the principles. So I just wanted to come back on the party autonomy part, the decision to work on party autonomy and the importance of the principles. And if we look at the preparatory work, what I think it's important to remember is that the decision to work on that really came from a practical observation on the needs. And there was a discussion at that time that across jurisdictions and arbitration, choice of law clauses were widely used, but their treatment differed significantly. So courts and tribunals recognized party autonomy, but applied it not always in a predictable manner. And this is, I see, for example, the information and the techniques of the cold dataverse exactly providing that same element of how much can we predict the results when you have a combination of jurisdictions dealing with that matter. This kind of calculation, and of course in the principles, the answer is a party autonomy with certain limitations, of course. And there was other conventions before in the commercial field that dealt with party autonomy, but not like the principles, right? And I think that's also why it became it is also the reason why it became a soft law instrument, as we say, a guide to best practices in this field. And I think one of important aspects that I wanted to also bring for the discussion in the conference is the scope, right? Because this is also important in the work of the Hague Conference, is where it's possible to find common ground. And that's where work is feasible, because there is consensus on where there is convergence on party autonomy. And certain categories were excluded from the work of the principles, because, of course, in those areas, there were specific discussion needed. But those areas that are included are where there is a very stable convergence between jurisdictions and expertise in recognizing party autonomy, and the choice of between the parties being the best one. And the exclusions are, of course, consumer and employment contracts, family law, succession and status, insolvency, and other financial relationships. And we also have an exclusion concerning proprietary effects, for also the reasons where there is it is more difficult to align between legal systems. But there, on the rest and where the principles addressed, there was a big alignment, and that's how the principles could find also this common and stable ground. We also find it interesting now at current work to discuss what the role of default rules. In this work, we also have undertaken the question. We've posed that question in the arbitration service that we do since 2021, which is a difficult question where you don't have a choice, a valid choice, or no choice at all. What is the default rule? And that is, of course, a lot more complex matter. But what is interesting is that since the preparatory work of the principles, this question was already posed as possible future work. And we see this now coming back, because in areas where there is a need for stability, but less space for party autonomy. So as I mentioned, perhaps for central bank digital currencies or carbon markets, there is a need for a more a default approach, even if there is maybe also some level of party autonomy, but there is a need to look back. But of course, this is the area where a lot of international coordination is needed. So I already mentioned all the developments and discussions. So digital platforms, automated contracted tokenized finance, all of this have really transformed the world of international contracts and also the work of the Hague Conference in the field of international commercial law. So on one hand, because there is so much discussion on localization, so now where are things located for everything that is digital and new? On one hand, you have this very strong presence of party autonomy, exactly because you cannot, if you look at jurisdictions, you cannot locate as an objective connecting factor where things are. So, okay, then that brings also in a space for party autonomy. But on the other hand, you also have new strands of work. So that's a very interesting interplay, I think, for private international law in the work of the Hague Conference in this balance. Okay, maybe the solution when you don't have this is party autonomy. But in the areas where not, that's okay. We're looking back at default rules for a number of projects. So objective, what we call objective connecting factors in the jargon of the Hague Conference. I think I can move back to the final point, which is the HCCH membership and how it became more and more diverse, and it is becoming every day we have more states involved in our work. It makes us our work very challenging to accommodate the diversity of legal systems, and not just as a very difficult interesting comparative law exercise, but that means also that we have more states represented in our work in the expert groups. And we also get feedback from instruments that are existing as the principles and with new questions. So that's why I mentioned in the beginning that the principles are very much aligned. But that makes it, again, the final point, why the Dataverse is so important, because it documents how groups operate in practice across jurisdictions and traditions, gives visibility to the reasoning also in this context, and also the methodology, right, that is used in this very detailed set of questions and in a comparative analysis. So this, if we think of private international law really shaped by diversity and with a lot of developments in a number of countries, I think the Dataverse provides some empirical grounding for us to study and to know better. We also, of course, have input in the work of the Hague Conference, but we see this is really, really a rich environment. So I think I can conclude, and then maybe we can have a bit of a discussion, because this is a very heavy, dense information on the work of the conference and the principles. But I just wanted to give a final word of celebration on the principles, because they do constitute a really important an international code of practices. We call it the model framework for party autonomy in international commercial contracts, and it serves as inspiration in many other contexts and as a guide with a very clear PIL analysis in a lot of different areas, including on forms, on public policy, on the levels of discussion that are very sophisticated and addressed for party autonomy. And they may be used, of course, by legislators wishing to reform and modernize their rules, and we've seen that happening already, and we continue seeing that happening. But what is very important, the principles provide parties guidance for choosing applicable law and also drafting a valid and effective choice of law clause, and that because you will know the effects of it. And I think the information that you provide and the analytical tools you provide also help with elucidating that. So the code initiative, I think, really supports a vision of private international law that is contextual, plural. That's also, I think, an important discussion, and responsive to this evolving field of cross-border interaction. I think I'll leave it there for now because it's already quite a bit I spoke and I don't want to bother you, but it's very interesting to see the other discussions as well and continue this discussion.
Thank you very much, Raquel, for this very comprehensive and yet clear summary of both what we are speaking about, the choice of law principles, and our project, the Dataverse, but also on the course of action that has been taken in preparation of the work and in the aftermath. And we are, of course, specifically concerned with the aftermath. And for that purpose, I would like to give the floor to Agatha Brandau, who has been here for almost 10 years here in Lucerne. I'm very privileged to have had her as our senior researcher in both projects. The first project, which was the publication of the book, the OUP book, and now the Dataverse, and she is the soul, so to say, of the Dataverse. So I'm very happy to introduce her as the interviewer, so to say, of our guest.
Yeah. Thank you so much, Raquel. The presentation is amazing. So much information in a concise manner. My first question to you is whether you see the principles gaining momentum as model law of sorts. So you mentioned the influence in Latin America, and I'd like to understand a bit better what is the position of the permanent bureau in these matters, or if you try to push it, or it's an organic process of sort.
Yeah, it is. We are there to provide the information on the principles and everything, but of course it's ultimately for the jurisdictions to decide. We think, of course, we promote the principles as a way of modernization, and we also part of the work pointed out to this also the cost effectiveness and the impact on the business and the economic side of things, of course, but at the same time promoting certainty also in terms of public policy. So it's this balance where we promote the principles to show to the jurisdictions what is important in terms of legal certainty and how these two things are creating a balance between the different interests. So one for businesses, international businesses, and providing a framework for operation, but on the other hand also guaranteeing public policy and overriding mandatory rules, the respect for that. So this is where it is, let's say, a selling point, but of course is for the states to decide and if they want to modernize legislation, if it's necessary for them. But it's beyond that, right? It's also for the parties. It's also for the courts and the arbitration tribunals to think of this model of best practices. See, so it's just one side of it is the modernization, right, of the legislation. But as a set of principles, the idea is to inspire.
Yes. My second question, you mentioned at the end of your presentation that what we are developing is good in terms of setting empirical ground for this kind of information and analysis. I'm curious to learn more. How do you do this type of overview or data collection at the permanent bureau, or even before, for example, you have the expert meetings, and I know you have preparatory studies. How do you do that in terms of comparative law? I know that you have connections with the central authorities, but how do you gather the data and how you treat this data and how you transform this into something useful to these meetings? And this is it's a lot of work. And here at the University of Lucerne, we have learned that data collection is key and quality control is also very important. But I wonder, how do you do this without a dataverse? Or what we are trying to do now is to centralize the information and make it available and transparent to everyone. And I would like to understand a bit better how you have been doing this so far.
Now, of course, I think there are two different things. Let's say the work of the experts groups are normally, we are informed by the experts themselves, representing, designated by the states, and they bridge that information. It is for the different experts groups. It's not always the case that we have representation of every state we are interested in knowing more. So that's where sometimes we bridge the information with the permanent group researching, but only to assist the experts group, of course. But I think that's one thing, the development of normative law. I think the other thing then is the future work program of the Hague Conference. And that's the area where the permanent bureau does do more research, internal research. It is more limited, of course, because it's an internal secretariat research, legal research. But that's where also we find areas for future work. And we normally, because we detect certain questions, private international law questions arising, and that's where we research. And for that, for example, we've also had the arbitration center survey to provide us with some insights, which were helpful also to signal to the council which areas we thought, okay. We also had, for example, I didn't mention the suggestion to work on the protection of group parties, for example, in different areas of the commercial law work, international commercial law work. And the arbitration center survey is very important.
Okay, speaking of the survey specifically, could you clarify when the new version will be out, or how many institutions are involved nowadays? Because it started small, perhaps in 2022 or one, and now it's much larger, right?
Yes, we have a very long list of arbitration centers. We are reaching out to them with the number of questions. And we hope to be able to process it shortly. Of course, it takes time because we also send a survey, they have to reply, and we have to analyze, and we want to make sure that we reach out to a lot of centers. But the questions are also, they are based on the principles, but they also go beyond, and the idea of going beyond is to see if there is a need of further work. And for now, we don't have specific work on, for example, the protection of neutral parties. But we keep on monitoring areas for work as part of the permanent bureau's work. And of course, the states, the HCCH members are the ones who decide on our work program. But we inform them with this information and with research.
Yes. Last but not least, I guess that one of the main discussions that are held nowadays about the principles is whether there would be an update directly to the instrument or not. And you already touched upon the fact that the foundation of the instrument is applied to other works, but would the principles themselves be revised at some point? Are there discussions, ongoing discussions on this? And second, it has been raised that the soft law format of the principles, well, it's innovative and it's a benefit in general on how flexible this can be applied. But would you have any further considerations regarding the potential of transforming this into another shape, hard law or not, whether these discussions have been raised at the council meetings or not?
Yeah, no, not yet. And actually, I think since 2015, the principles are still very much being promoted and states fully engaging. So there's really no ongoing discussion at all to change or at all. So this is really stable, and only what we are seeing in the current normative work, because quite often we talk about a scope that is excluded, for example, from the principles, or so, for example, business to consumer contracts, and then we have business to business contracts, but for example, now in platforms, and that's part of the new work. There could give origin to a specific instrument for platforms, for example, but that's still to be seen. It's very early to know, and also very early to know about the binding, non-binding nature, because those expert groups are especially this group, starting to discuss more concretely instruments. But I don't think, I think for now there is no plan to change it, but only to continue using it, and just identifying areas that are, let's say, adjacent to it.
But that's already very interesting. Thank you for clarifying this. I have one final common question to Professor Daniel Gisbert too, and I'd like to get your take if you have any remarks regarding this. So more than 10 years ago, the principles were out to the world. They were enacted. I know it has been a very interesting and time-consuming process of meetings since 2010 or 2011 of sorts. So at the Permanent Bureau, I think that the discussions started in 2010. Is that
2009?
2009, and then the experts group were then assembled. I guess Professor Daniel Gisbert can say how lucky they were to find these minds across the world and bring them together to actually produce such a solid instrument. And if you were to go back in time and consider this history, is this vis-a-vis your expectations, or and also, I mean, from our research standpoint, so precisely 10 years ago, 2016, you had the conference here in Lucerne, and many people came to celebrate that the principles were available to the public, and now we are launching something new, the Dataverse. I'd like to get your take on this. How do you feel? And it's also closure. So how does it feel?
It's amazing. It has been a great journey, and I'm sure it will continue. When I was asked in 2009 whether I was interested in chairing the working group of this for this instrument, I would never have thought how intense and how interesting the journey would be. And it was always a pleasure. It was never, I mean, of course, we had a lot of controversial discussions in the working group, but it was always the feeling that one wanted to achieve something helping the community. And I think that really we succeeded in doing that in quite a short time. I mean, it's 5 years of work. I don't think for a Hague instrument that's a long time.
Multiple.
And to write the book was not so difficult because we already had the authentic interpretation by having a commentary already for the conference, having prepared a short commentary for the conference. So that was more of a comparative law exercise, which was fascinating, as you know, because you were an important part of it. And then this Dataverse was really also fascinating because we didn't think about AI when we started it. We were funded by the Swiss National Science Fund, which asked for a lot of information before granting money for such a project. And at the very last minute, we introduced the AI part. We even had to change our application. So that was both surprising for the National Fund and for us, but it worked out, and I'm really happy that it did. And I really have the feeling that this Dataverse, although it seems to be limited to choice of law, which is a rather narrow field, can serve as a tool for using this type of AI help to the community of both practitioners and academics in private international law, or even the law as such in the future. And I think that the value of having that is quite considerable, and it's more than just private international law.
Very happy to hear that. And Raquel, any last words regarding the institutional position, the 10-year anniversary, and expectations, what you have seen in the background?
Yeah, I mean, thank you again for giving us the opportunity to talk about the principles. I think we only see like a lot of work to do and a lot of follow-ups to do, and that's a very good thing, right? So we have a lot to do in this field, and a lot to know and to work together, and it's really interesting and a pleasure.
Okay. Thank you so much, Raquel. Rurik and I, now we have bilateral Q&A appointments. For those who could not schedule an appointment with us, you can drop us a message and we can make ourselves available at a later date to keep the discussion going. Thank you so much for connecting. Daniel, any last words?
No, I hope that this final conference, which is unfortunately not a physical conference in the first place, but rather hybrid or mainly virtual, will assist developing these projects further and interest even more both HCCH members and practitioners and academics in this field.
Good. And for those who are online with us right now and will not have a bilateral appointment, you can take a break, and at 5 p.m. we'll be back presenting our AI application, the case analyzer, and you can learn more about the research that we do at the Dataverse in general. Thank you so much.